effect on getting the case to the jury in a timely way where we're all comfortable with that, you know?
Yeah, I think the upshot is we can still get it done.
If you want to
Even
take,
if it have to
yeah.
come off, we can still get it done.
If you want
That
to,
sounds- That sounds correct, and I think we're on schedule, even if there be a penalty phase, to get that in next week,
Yeah,
completed.
I agree.
that part's looking that way to me as well, but even for the flow, if you wanted to take time now, just a pause to call, Broward, the state attorney's office, that's probably worthwhile doing that. And then you find out one way or the other, as soon as you can get an answer.
Yeah, I mean,
Because
she's
you're
in
all
Broward.
kind of been busy, you're doing this and they're doing that, and, if there's any way to kind of get a hold of them,
Yeah, I think she's in trial right now.
the prosecutor.
Right.
So maybe after hours, you think?
Yeah, yeah. I've already spoken to her.
Yeah,
Yeah,
okay.
I'm gonna-
All right, so, all right, and then,
Okay. Are you good with this, or?
No.
Do you have an issue? I mean, is this something we
We
can
can
address
talk
right
about
now?
it
Okay, go ahead. Ms. Mitten, I think, has an issue with some of the hard drives in this case, so I'll let her address it.
the hard drives.
So the state has just provided me now, Judge, 3 different hard drives that are the total of the Waste Pro videos and audio. Again, for the record, this is a capital case. It is incumbent upon me as defense counsel to view everything that is digital evidence that is meant to go back into evidence, and it becomes evidence of the case, to ensure that it's properly in evidence and that it is what the state purports that it is. There is not sufficient time for me to do that now with the amount of video and audio on those drives. It's not something, I did take a cursory review of the file types on it, but to have listened to it and watched it, I cannot do that in this amount of time. Over and above that, there were redactions that were requested of the, I'm gonna say video and audio as an amalgam, both the video and the audio. There were redactions that were requested, and maybe I improperly assumed this, that the state would redact that from evidence. They have not done that. And so there is extremely prejudicial audio and video on those pieces of evidence that the state seeks to introduce into evidence. The state has conveyed to me that they do not intend to send those items back with the jury. However, they would be improperly allowed into evidence, and I have a legitimate objection to the items. If we could have Mr. Walker step out, Judge, because the rule of sequestration has been invoked, and this goes to another witness's testimony, before I say what I'm going to say, is on the tape.
Okay, Mr. Walker, if you could step into the hallway for a minute while we sort this out.
Sorry, Judge, I just want to make very clear for the record the impact of the thing that's on those items on the case. So there is a reference on the audio and video from the Waste Pro truck that my client or an intimation that my client has committed a previous murder in a different jurisdiction. Obviously, that is extremely prejudicial, both for guilt phase and penalty phase. And I moved to redact those items from the translated transcript that the state had informed us that they were going to seek to introduce into evidence. I again made, I guess, the improper assumption that it would also be redacted from the evidence itself if the state was intending to put those pieces of evidence actually into evidence. The state has now informed me just now that they would like to put the unredacted video and audio into evidence with that information on it that I've just relayed to the court. I have significant problems with that. There are also other audios and videos on the third hard drive that are not translated and transcribed in the transcripts. And so they're in Spanish. I have no idea what they said. So I cannot agree to allow those items to go into evidence when they've neither been translated nor transcribed. I don't know what they are.
Let me digest this for a second here, taking notes. Before I hear the state's response, do I understand correctly what we're talking about on these hard drives is the audio and video, the garbage truck audio video that's been subject of this case for 7 years? That's been the main evidence that when I ask myself, why is this case going to trial in 2025? The answer has always been because we have this audio video on a garbage truck and it needs to go to the FBI, it needs to be enhanced, it needs to be interpreted. It's been the main subject of the case. That's the first question. I'm not saying that, it sounds like I'm saying that in a pointed way, and maybe I am in part, but I'm really kind of scratching my head. That's what we're talking about. So, first of all, that's my understanding, that's what we're talking about now?
Yeah.
And on these videos and audios, we have three issues that flow from it. One is it's claimed by the defense that they don't know, they have to review it because they're not familiar with it. Number two, there's something on there that was not anticipated. And then number three, there's this issue of the redaction of materials that should be deleted, which came to my attention. I think that I hearken back to the Friday. We had the jury panel filling out questionnaires, and you all were standing right here, and we were litigating something else that we don't agree that on deletions. And I was thinking, well, they better get it done because the case is 7, 8 years old. We're about to be in the jury trial. That's something normally we sort out pre-trial months, years before, so that we're actually ready to go. That's the way I'm perceiving this situation. I just want to make sure I'm perceiving it correctly before we determine what, if anything, can be done to rectify this. So that's my introduction or questions that I have with regard to this. What's the state's response?
Yeah, so let me
Just kind of hone in on the issue. It's not a Richardson violation situation, but
Right.
it's more of the practical situation. Maybe it is a Richardson violation. I'm just not sure exactly what is going on here because it just doesn't seem possible that we could be in this posture as I sit here after 2.5 weeks of doing this actual trial, that this is happening. I can't wrap my mind around that. Go ahead, Mr. Richardson.
Right, so there's three issues here, I believe. The first, I'll start with the hard drives that were translated by our translators that will be introduced in evidence, which is exactly what the court's talking about. The first is what's been marked as exhibit number 169, and it is the translation of the August 24th, 2018 Waste Pro video, okay? This video was...
You see, it's a translation that's on a hard drive. In what form is there a translation? Is it someone speaking the translation? Or what are you talking about?
No, I'm sorry. I'll be more specific. It is the videos from the August 24th, 2018 Waste Pro truck that resulted in the transcript, and it is the videos that were relied upon by translator Rose Rosario to arrive at her conclusions that are spelled out in her written translation.
How is that different from audio and video from the garbage truck? Which is enhanced?
Right.
Okay.
Yes, yes. These were enhanced prior to being received by Rose Rosario, and she used that enhanced video and audio to arrive at her conclusions in that for her translation. This particular hard drive, which is States 169, is in discovery, and it has been marked as SAM State Attorney Media 0072, and that has been in discovery since the state's 61st supplement, which I believe is 2023. The transcript of the translation is found on page 2264 to 2278. So
you're talking about an item standing alone, or is that on this hard drive and it's one piece of evidence along with other pieces? I'm not sure.
no, what's on the hard drive are audios and videos that have been enhanced by the FBI that were translated by Rose Rosario. The transcript itself is not on the hard drive, if that's the court's question.
Well, when this all started with you walking up here with a hard drive that had a cord on it, and the objection was asked, I'm just not clear what's on what.
There's 3 hard drives.
There's
three hard drives.
So let me walk you through.
All right.
Okay. So that's the
One
first
of the hard drives is what you just described.
Yes, which
Okay.
is States Exhibit 169. Okay.
Okay.
So let me move on to States Exhibit 170. This is the hard drive that has also been enhanced by the FBI, and it is for the video. It has video and audio for the remainder of the days. So that would be August 21st, August 23rd, August 25th, and August 27th.
So what was
This-
the date of the first one?
The first one was August 24th.
And the second was just other days.
Correct. Yeah. So this one was used by FBI translator Norma Campos to arrive at her translation. There is not a written transcript on this one either. Okay? And then that is SAM 000 or 0079, which has been in discovery for more than a year, I think. I don't have the specific supplement on there, but it's been for a while. There is a, hang on, I might have it right here. Yeah. Yeah, I can find that particular date of the supplement, but I believe it's been at least free. It's been in discovery for at least a year. Yeah, I didn't put that down. Hold on. Okay. Then the third hard drive is States Exhibit 183. So, States Exhibit 183 is a compilation of all of the data that was, one, obtained by the St. Lucie County Sheriff's Office, and two, analyzed by the FBI. The analyst's name is David Mingarelli. So,
What type of data?
Video and audio.
That gave rise to the previous two exhibits?
Yes, sir. Right. Yes, sir.
Okay.
So to address the redaction, and all of that data that's contained on that particular drive has all been in discovery for well over a year. Most of it has been in discovery since August 27th of 2018.
So there's no
So-
discovery violation? For Richardson hearing purposes,
No.
there's no discovery violation. Do you agree with that? Let's start there, because for appellate review, that's what they're going to be focused on. Is there a discovery violation first, before we get into whatever else is going on here?
Yes and no. If the state is saying that every audio and video that are on those 3 pieces of evidence have been translated and transcribed, then no. If, however, there are video and audio on those items, which I believe is what Mr. Richardson told me is on item number 183, that has neither been translated or transcribed and provided to us in English, which is the only language that I speak fluently. This presents a problem for another reason, Judge, and it goes back to my even trying to say is what's on that piece of evidence that we're going to put into evidence. Is it what's in the transcript? I don't know. I don't speak Spanish fluently enough to be able to say that. So I don't know how I, as a lawyer, can properly review it to make proper objections to it other than just what was on the translated transcript. That's what I redacted. I redacted that.
This is reminding me of the issue we had earlier with the summary of the FBI cell phone stuff. Is what's going to happen is the state's going to be moving these, like item number 3, 183, into evidence, which is compilation of all data, but it's not going to be what your witnesses are testifying to, which is we're in a trial where there are allegedly admissions of the defendant saying incriminating things. That's what's relevant here. Is the state just going to be trying to throw in a whole bunch of statements in Spanish, what's not interpreted, we don't know what it is, and that's what the defense is. That sort of like before, we had a whole thumb drive of stuff, a whole compilation. It's really not the evidence. Is that what is happening?
No.
So I'm still trying to get my sea legs and find out what the heck is going on.
Yeah, no, I understand. So the point of the 183, which is the compilation, is I have to show how they arrived at their conclusions and the data that they used to arrive at their conclusions. So I'm going to...
Says who?
So that we have an intelligent account of everything.
The intelligent account would be there's a garbage truck, there's audio, video, the defendant's person on there, and the interpreter hears the Spanish and said, these are the words he's saying.
Yeah.
I don't know what the purpose of 183 is your problem, right?
But that's the main problem, Judge, because I don't know, the state has informed me that it has items on it that have not been translated and transcribed. So as to 183, again, I can't say as an attorney, is it admissible or not? I don't know what it says.
Well, look, I mean, if they're willing to waive any objection to it, then that's fine with me. I won't admit it. But
We
the
should
whole
waive any objection to what? I don't think that's clear what you're
to
saying.
the introduction of 183 specifically.
Is 183 the part where the defendant says the incriminating things that Mr. Cormier referred to in his opening statement?
They're in there, but they're in there, yes. But the state is going to rely on the...
Maybe I'm sorry. Maybe I don't understand correctly.
Yeah.
169. 169, is that the one that is that's the Spanish video, audio that your interpreter is relying on to say the things that Mr. Cormier said in the opening statement?
From August 24th of 2018.
Right.
That's the one.
Okay.
Yeah.
So where I'm missing the boat is I don't understand why you need to get into all the other stuff. If the main stuff was enhanced, then it's in item number 169. The testimony would be we had audio and video from a garbage truck. It was enhanced. I'm a Spanish interpreter. This is what it says, and you even have something to play for the jury if you wanted to do that. So that's why I'm still trying to figure. But you all are shaking your head in the affirmative, like I'm understanding where you're coming from.
Exactly.
And of course, hopefully this is separate from the issue of whether something needs to be deleted from. That's a separate issue.
Correct.
Right.
So.
Yeah. So
The defense position is we can't just willy-nilly say, okay, let's put in 183. It's got all sorts of stuff on there. We may have jurors that speak Spanish or something in there that they're going to interpret. We don't know. It's being said. We do have Nancy Hernandez, Rebecca Cedeno. I'm just looking at our jury panel, people that might be fluent in Spanish. Nicole Hurtado, these are Hispanic sounding names. But if, aside from that, I mean, you wouldn't put in a audio video in another language. We don't know what's being said on there. I don't know why you think you need to do that. So you said because to establish a foundation to do that, and that's maybe where the rub is here. I'm not saying that. Yeah.
So
That's why I saw Jim. I'm sorry. That's why when you said if they're willing to agree to its admissibility, I thought you're talking about 169 and 170, saying if they're going to object, well, there's no foundation for this. We don't have the original raw data, basically. Is that what you meant by that?
Yeah.
But I don't think they're going to make that objection.
That is not the objection we're making.
Okay, well then that totally changes.
Okay,
that
that's why I go
completely
through
makes
this
things
whole
more efficient. Yeah.
rigmarole.
That's
to
our
get-
concern. We don't know if they're gonna challenge how we got to this point. So then we have to then show, here's what we started with, then the FBI enhanced it, then it went to a translator. So that's why we
So
have.
you're anticipating an objection that's not
Exactly.
coming,
Yes.
right? The
Correct.
objection is not coming.
We're
And I-
objecting to something, Judge. That's not what we're objecting to.
Right. So the foundation for the material exhibits is that there was raw data, it was enhanced, here it is, and here's what's going to the jury. But so I understand the defense position, well, that's where you are. Now, on cross-examination, if they were to say, oh, you made this up out of thin air, maybe this is artificial intelligence-generated audio and video, that doesn't look like they're going there, but and that's where you're anticipating they could do that.
Yeah, right.
In the artificial intelligence division of the FBI. But it's a joke, but
right.
there are
But-
people that believe a lot of stranger things. But unless
Right.
it's raised, I mean.
Yeah, but I prepared the case as if there was going to be objection in order to make sure my evidence
I
came in. But if they're not objecting,
Okay.
then that's fine. I got no
Okay,
problem
so
with
that
that.
takes care of that issue.
Yes,
Now
yes.
we have,
That's fantastic.
it is fantastic, except I hearken back to the Friday when you were all standing here and you said, well, they have some requested deletions to what's on, I think, is it 169 and 170?
Yes, sir.
And I was hoping and praying that was all going to be sorted out and we didn't get to this point. And the silence I took as a positive sign, but maybe that was too optimistic. But that lingers. Because it's referenced, and you referred to it as someone, either the defendant or Mr. Alvarado, I take it, because those are the two speakers on the audio and video, my understanding, made reference to some other murder, non-existent murder probably, right? Or
So,
defendant has been convicted of another
right.
murder.
So let me explain to the court the state's position on the redactions. We only received their redaction request, I believe, last week. What we have done, what we've already done, if I understand correctly, is we've already redacted the transcripts, and we agreed to all the redactions. We've redacted their transcripts, but in order to redact these hard drives is exceedingly difficult. Number one, because they're in Spanish. Number two, because they're difficult to play, just from a pragmatic standpoint. And it would be very expensive too, because we have to have somebody with the ability to sit down and do that. I think for Rose Rosario, we paid just to
All right,
translate.
so let me just interrupt you there. This may
Yeah.
be a problem that I can solve by dictating the way the evidence goes to the jury.
That's what we're agreeing.
Right.
If we play anything from those videos, we would just show them what it looks like and what it sounds like. We wouldn't play a part where there's only very specific parts that
It's
are
exactly what I
Yeah.
was thinking of, and
we're-
not
we're
allow
in
that.
agreement to that.
Yeah.
Not allow the actual audio video to go back to the jury, if for no other
Exactly.
reason too. We could have Spanish speakers, and it solves that problem too, so they don't do their own translation. They rely on the evidence from both sides as far as what's being said there.
Yeah. And I just got the redactions back probably 10 minutes ago. I just forwarded them
Right.
to the defense. And what our intentions were that everyone will have a copy of the transcript while it's being read, and they'll be reading it, but it will just be redacted.
Maybe that's overly optimistic. Go ahead, from the defense.
I don't know the efficacy, Judge, or on a, 3851 purposes
Mhm.
of me agreeing to allow such explosive and prejudicial items into evidence, even if we don't show it to the jury. Because now it's in evidence, can they use it in penalty phase? I don't think that we can,
We're not
like,
gonna use it.
We're not using it.
light put it into
Right.
evidence.
I understand your concern, but no, that should not be a worry. That should not be a worry.
Okay,
And this is sort of like when I give the edited recording instruction to the jury. If you had to play parts of it for either, this is what I was thinking practically, for either side, if you're going to challenge the translation of what you all both agree on is the evidence, you would just have to play that piecemeal. But I can instruct the jury. The reason we're doing that is we don't have a form where we could edit it and do that otherwise. So that's why it's coming to them piecemeal. So it's the same place we get to as if you edited it and I gave the instruction saying, well, you know, there's other stuff on there that you're not hearing. You're not hearing it because it's irrelevant to the case. So that's legally, that's a perfectly comfortable position for us all to be in. Logistically, that's on you, so long as you can live with that. That's where, so long as you can live with that. Because I do hear from at least the state side, I think I heard Mr. Cormier say you're going to play parts of it just to see that there's a basis that they were actually.
Yeah, we have to show them that, like, we actually
There's-
have something, we didn't just make
Exactly.
it up.
Right. And likewise, I could see in the defense side, because I don't know where the road took you with this, but there was a time when you were both disputing what the actual translation should be at the time. But you would be able to do that.
yes, sir.
But I mean, I would make a clear ruling that the only thing that's actually in evidence on the hard drive is what the basis of the translation is, the transcript, right? I think each side had a transcript too in the case, right? The state had a transcript.
They had their own
Right.
transcript prepared, which is very
Okay.
similar to ours.
Right, so we covered a lot of ground there. How do we want to shore that up so when we get started with the jury on this, we, remember what we did and are able to set it in stone? Is there some way we can set it in stone now and memorialize it so we don't get into a situation later where you're up here arguing about what we just did here and the understanding of where we're going to go?
It sounds like as far as those three exhibits, if they're not gonna object to us introducing the other two that just have the videos that they relied on the translation, then that part's gonna be fine. And they may have other objections at the time, but it sounds like.
So
we're
the
good.
ruling would be 183 is, you're not going to put 183 in evidence because you don't need to.
Correct, right.
169, 170 would come into evidence, but only for the purpose. Now, do you have a transcript that's a separate exhibit?
I do.
Okay.
One
Two.
transcript per drive.
The only parts of 169 and 170 that are in evidence actually are those that cover the other item, the actual
It's just
physical.
audio and video, one from the 24th, and then the ones from the 21st, the 23rd, the 24th, or the 25th, and the 27th.
Item is in evidence, but, meaning the hard drive, but what's on the hard drive that is the evidence is what overlaps your transcript.
Yes.
And you're not going to be exposing the jury to parts on the hard drive that are not that, because that is the actual evidence on those.
Agreed.
Right.
Well, it's similar to, I've had other cases where, going back to my analogy to edited instruction, I've had this come up before in 2 decades. We get the last minute and we didn't sort out the addition, so the way to solve that problem is the item is in evidence, it's not going back with the jury, you hear that, which would be the same situation here too, by the way. If they want to hear that portion of 169, 170 that overlaps the transcript, we would bring them out. You all would make sure we're not exposing anything on there that's other than what I just said. Similar type to.
Okay, so
Right.
there would be an item in evidence. Part of it would be shown to a jury, some snippets of the recording. Some of the jurors speak Spanish, and do we expect them to then say, okay, I'm satisfied with that, and they're not going to ask to see the rest of it? This is a video with purportedly the defendant making a confession. What are we going to tell them when they say, can we see the rest of the item that's in evidence? No?
Well, that's a separate issue. I'm all ears for that separate issue. That harkens back to the concern about whether they're Spanish-speaking jurors. that's something for, I'm not poo-pooing that issue. That's a separate, significant issue for us to discuss. It may be, this goes back to, I don't know how the show is going to go. Maybe that if you are going to play parts of those just to verify that there really is a basis for this, there really is, that you do it on something that you both agree on, that there's no contest about whatsoever. And if they were to ask to hear more of it, which is really the point that you're broaching, maybe the
items in evidence, right?
right, maybe the answer to that is they can't listen to it. It could be because of the concern that you have, that we're basically telling them. And you both are you planning on calling an expert to say our interpretation is the better one? Because let's put it this way. Well, I guess one answer I could give you now is, considering all the ground we've achieved here, we may put that off and see if it actually happens. But if it did happen, I would consider saying they can't do that, because what would be the purpose of it other than to invite them to do their own interpretation?
Right. Yes, that's true. Conversely, what is the purpose of entering something into evidence if it's held back from the trier of fact?
It's what Mr. Cormier said, just for the purpose that it's in evidence. The jury can't hear the whole thing, but they're establishing the basis that there's a corpus for the interpretation.
And if we had more than 8 days, we would have made a way to redact this, but obviously we can't do it with everything that's been going on in a short amount of time.
It's functionally impossible with all the witnesses and things that we've been dealing with. So, I mean, I
to
think
your
that the
point,
easy-
though, in the last point, the only alternative otherwise would be only to put in evidence the state's actual transcription of that. But that does seem awkward, because the jury has no idea of where it came
We
from.
would certainly object to any transcript coming in as anything but an aid to understanding.
Yeah, so I think the place we landed, imperfect as it is, the best possible outcome.
Yeah, right.
Did you want me to shore that up as far as, can I do that at this time with not having heard the predicates? I can't do that. Y'all will remember what we did here.
Well, I just want to make sure, because this is very important. I had planned that there was going to be an objection, and so I essentially have called enough witnesses to establish almost a super predicate, a way to super authenticate this thing. So I've got everybody in the chain. I've flown people in. They're all in the Gary Morales room right now, waiting to testify. So if the defense position is I can authenticate these only through the translators who will say that these have been enhanced by the FBI, and this is what I use to rely upon when I form my conclusions or my opinions, then that's fine. I just need that on the record now before I release people and they go fly back to their different states, and then all of a sudden they withdraw their objection, and I'm stuck.
I'm not sure I understand your concern, but perhaps it's more important that they do.
I don't understand it either, Judge.
I have multiple witnesses who were going to testify as to 183, right? 183 is all the data and videos that were used by multiple analysts to enhance and arrive at the enhanced versions in 169 and 170, okay? If they are waiving their objection to the authentication, then that means I don't have to put in 183, and that means I can release multiple witnesses, and that means I can introduce 169 and 170 through the specific translators who translated each of those respective exhibits. If they're okay with that, then I'm okay with that. We shorten the trial. It makes it easier for everybody. I think it's a win-win for all parties. and we go from there.
I want to speak for the defense, but that's what I heard them to say.
Okay.
However, I would assume you have some witness to say it went to the garbage truck place and retrieved audio and video, because the FBI people didn't do that, so that's
Yes,
part
that's
of
one of my witnesses, right.
Right,
They got-
right, so you could talk about them agreeing to the foundation,
Yeah.
that's part of the foundation too, it is, there's the audio and video. But you're talking about not needing the bigger one to get the little ones in, and that's what I
Right.
heard them to say that very clearly, that we're not gonna require that.
I just want to be clear, Judge, because we're talking about two separate things. We're talking about witness testimony and we're talking about 183. I wholeheartedly object to 183 coming in because I do not speak Spanish professionally enough to say what is even on 183 to make logical objections to it. When the state's asking, will I stipulate to a predicate as to 169 and 170, please, I want it to be clear, I'm not going to object to like a chain of custody situation, but I would require, and the way that I would do it, if I was them, is I put on the witness, like Your Honor said, I got it from the waste road truck, I sent it to the FBI. FBI agent says, I enhanced it using blah, blah, blah software, and then I sent it to the translators. And then, boom, we're at the translators, and we're at 169, 170, and then we're off to the races.
Mm-hmm.
That is what I had expected them to do, not bring in 183 that I don't know what's on that, because no one translated that.
Right.
And to be clear, I just want to be clear, everything that's on 183 has previously been disclosed in a variety of different SAMs and discovery as well. So I want to be very clear about that.
I think we're going backwards now.
Right.
I think the state should go forward. We didn't have a hearing about whether the state is authorized to release its witnesses. You have to do what you do as far as part of this case, as far as whether you want to release them or not, that's up to you, but we had our discussion and it led us there.
And Judge,
Because I can't foresee everything that's going to happen and be responsible if you release the witness that's relevant for some other purpose that I can't see, and that's not my role. But I think the defense spoke pretty clearly to it as far as how we're going forward.
and Judge, if I may, since we're on the topic, I don't want to do it in a half measure. We do have a different objection to the translated transcripts. So I don't know if we want to take that up now,
This is 169 and 170.
and then whatever pieces of items of the state's evidence, the two transcripts are that correspond to 169, 170. I didn't hear if they said the numbers of those yet.
No,
The actual
we haven't,
transcript.
we're not at that point yet.
Right, so it would go to more specifically the transcripts themselves. And it's a legal argument, so again, I don't know if you want to take it up now or,
It's up to the state. I don't know if anything that we said or determined is contingent on that, or if it's completely separate.
completely separate, but we need to address this second thing before we can even determine if that transcripts come in. If that makes sense.
What is it? Just tell me what your legal issue is. So I can-
Sure, it's Martinez v. State, it's
Yeah.
761 Southern 2nd, 1074, about authenticating transcripts in use in a trial.
It's a Florida Supreme Court case that lays out procedures for trial courts to follow.
And in Martinez, the transcript is in English, and it's still supremely problematic. And the way that the state, I assume, intends to introduce this transcript doesn't even meet the requirements of Martinez. And again, Martinez is in English. So we've added an extra layer of complexity, and I did bring this up before because it's a translated transcript, which makes it even more difficult. And can I give the case here?
I think I know that case. I've looked at it in the context of our last hearing we had about this. And when I looked at it, frankly, I determined it was not on all fours. It's a different legal situation here. This is a different situation.
Judge, if I may,
Yeah.
just so that the record's clear, and I want to make sure that I lay this out specifically for the record. It's a use of a transcript of the defendant Martinez, and his wife is a participant in the conversation in the transcript, much like Eric Alvarado is a participant in the conversation of the translated transcript in our case. And it starts on page 8, first column, and they talk about the recording itself, and they say to a large extent it's unintelligible and therefore incomplete, which is what we have in this case as well. There's many portions that are unintelligible, even in the FBI enhanced
In that
one.
case, though, in all cases such as that, there was not an actual interpreter on the stand subject to cross-examination regarding his or her testimony, which is what we're going to have here. And the transcript just memorializes their actual testimony here in court, meaning you could literally not put the transcript in evidence, which would be the other way to go. You don't put the transcript in evidence, you just literally have the witness testify verbatim to what he or she translated. So it's,
I think maybe we're
it's a different issue than there's something that's not clear, and the judge determines which transcript should go to the jury as being accurate. This is a different situation.
What Martinez tells us, and I think what we may be losing sight of here, is the transcript is not the focus, it's the recordings. The jurors their job is to determine the accuracy of the transcript as opposed to what they're hearing on the recordings. How can they do that in this case with the recordings in Spanish? It doesn't matter what the translator says. The jurors have to hear and compare. They can't just take the word of the translator.
They would have their own translator that they present during their case for what they say is not consistent with our translated version.
And that conflicts with what we talked about before. In that case, the state puts in the, as far as they're not limited to just playing 169.70 for parts that you all agree on. They put the whole thing in. And then we're left with the jury. If they speak Spanish, they're able to do that. There's nothing prohibiting them from doing that. It's a different situation than using a court interpreter and telling the jury,
Right.
there's a witness testifying in Spanish, just rely on what the interpreter said. So if you can't have your cake and eat it too from the defense, you either put the whole thing in and the jury's left, if they speak Spanish, to make their own determination and judge that and judge the credibility of the interpreter, or we go the other way. I'm fine either way.
Judge, the other issue that's
Yeah,
raised
but which
by-
way does the defense, you can't have your cake and eat it
The
too.
other issue that's raised by the case is the transcript is not supposed to be a focus of the trial. Now, how is this not going to be a focus of the trial? You already earlier opined when we started discussing this motion that this is an extremely critical issue in the trial. This transcript, and as the Martinez case says, the risk is that the jury, who doesn't really know what's on the recording, is going to artificially enhance the importance of the transcript and treat it like evidence.
But that's
a risk in this case, and since it contains what is purported to be the confession of the defendant, it's going to be a focal point of the trial, which is not supposed to be according to the
Because
Florida Supreme Court
the
case.
the interpreter in this case is an expert witness, and the jury can accept or disregard everything that person says. That's what your case is about. You're going to battle
Correct.
of your interpreters,
And
which is
that-
what makes this case different.
Well, that argument would be true that in any case where a defendant confesses in a different language,
Right.
then we had to have it translated. That argument would be there. And
Right.
and I know you also, there are supplemental, or there's instructions during trial for the use of transcripts when it's either in,
It's
if it's
in or-
in dispute or if it's not in dispute. It even addresses, I know some of you speak Spanish in this case, you have to rely on what the translation is.
But those, to me, are red herrings on both sides. That's dealing with a totally different situation. You have a Spanish-speaking witness and an interpreter. It's a different situation here. And I think I mentioned too, previously, I do not want to be commenting on the evidence in this case. You have a dispute between interpreters, or at least you had a dispute. So maybe the situation now is that the defense said they're not calling an interpreter, so they have a battle of the experts.
Judge, can I just
Yeah.
read part of?
But it's not helping me because I don't know where we're going factually and what we're going to get to.
Well,
Now
you do have to make an independent interpretation. According to Martinez, the court should
But let's,
also make an
wait,
independent
wait.
determination.
Mr.
backwards.
Burns, let's lay the foundation. This is what's going to happen. you're going to get 169, 170 come into evidence as an enhanced version of the garbage truck audio and video, the audio, right? Then the state's going to call an expert interpreter to say, I'm an expert interpreter, I listened to it, this is what's being said, and I'm using my expertise and skill to say that. And they're going to go, you could literally have them go point by point. This sentence, the person is saying this. And the transcript of that is verbatim identical to what the testimony of the person was here. So there's really no danger in that. So long as they testify completely consistent with what they've written down, there's no conflict between the transcript and their testimony. The transcript is only there, and my concern with the transcript is they would have to testify to everything that's in the transcript, which goes back to how long we're going to take to try this case. I don't know how long it is. I've asked that question before, but I was told it wasn't that long. But they would have to do that. So the problem would only arise if the witness does not cover all that ground, and now we put a transcript in without them covering that ground to substantiate what's in the transcript. The transcript would really only come into evidence because you all agree it would assist the jury in remembering what the person said if there's a stipulation. If you object to the transcript, I might sustain that and say the witness has to testify verbatim to do that. And you could use the transcript perhaps as a demonstrative aid in your closing argument. Say, he or she said this is what it says.
I want to make sure I understand. I believe I'm correct that the fundamental task of the jury here is to listen to a recording and match it up with a transcript. Here they can't meaningfully do that. They'll have an expert tell them what's on the recording, do their job for them, and the court is saying, well, if they believe the expert did the job correctly, that's good enough?
How else do you think it would be proved to a jury that doesn't speak Spanish what's being said on an audio, other than to have an expert Spanish-speaking person come in and tell them, I'm an expert in Spanish, and that's what's being said? It's really very simple what's going on here. This is not rocket science to do that. So if you're going to, if the argument is about whether the transcript comes into evidence on its own, which is really what the focus is, that's an issue. But there's no other way in fairness for either side to prove the contents of a Spanish audio than to have an expert in Spanish come in who's really an expert say, this is what's being said, and explain it to the jury. And then the jury gets to pass on the expert witness, just like any other expert. Are they skilled enough? Do I reject their testimony? If I accept it, that's what's being said. And the defense is free to call their own person to dispute it, or to cross-examine the person and, to destroy their credibility by impeaching them. But simple as that. So I suppose the question I would pose to everyone here is, that's the foundation. What I'm telling you is the expert's going to be allowed to come in and say 169, which is enhanced, meaning all the noise was taken out, it's as audible as it can be. That's all that this is.
Sure. Is
in evidence, and it's there, and they're going to testify as far as the contents of it. The transcript is just to assist the jury in understanding their testimony, which it could be problematic if they don't cover all that ground. So we'll take that when we. If you want to object to that, you can. We'll go from there.
I just want to point out one additional thing, Judge. The Martinez court expresses preferences for certain methods of resolving these matters. The chief method of resolving the matter is to have a participant in the conversation authenticate and verify. We have such a person here. We brought him from Connecticut. The state did. It's Eric Alvarado. The state is deliberately eschewing and rejecting the best method of solving this by keeping that witness off the stand to try and work it through what the Martinez court says is a second best way of having translators come in and say this is what's on there. Why are they not bringing the person who was a participant in the conversation in to tell the jury yes or no? Why are we resorting to a second-tier answer?
Well, I mean, that could be a play that I do, but I'm going to authenticate. My intent was to authenticate this without Eric Alvarado.
As the silent witness, as we discussed before.
Correct.
Right. And there's been a change too. Before Mr. Burns said that, I thought Mr. Alvarado was testifying because all of the arrows were pointing that direction to me
We would love nothing
previously.
better than to see him in the witness chair.
We did a whole thing about, Mr. Richardson with the jury. Witness comes through the door over here. These are the dynamics of litigation.
Right.
Well, maybe I should be more open-minded to that case, but I've looked at that case. I really have. I don't think it helps me in this particular situation. I think you've boiled it down to the essence of what we have here and go from there. That on the issue of the transcript, I'm not overruling your objection. Let's see where the road takes us with that witness. But it may be, if the defense doesn't agree to the transcript coming in, it may be that the witness is going to have to testify verbatim at every, the witness could use it to refresh his or her memory as far as the interpretation, but they're going to have to literally interpret it on the stand.
You mean as the recording is playing?
No, just, they would have to say, they're going to have to
Oh, yeah.
speak
Yes.
the transcript.
Yes,
Speak
and that
the
was
transcript.
yes, that was our original
How long is
plan
it?
anyway. Yeah,
How long
yeah.
is it?
So,
How long is the recording?
well, exhibit 169, I
Yeah.
think, is 12 or 13 hours.
Oh, we'll
But-
just be here till next year then.
Right.
You'll be here, I won't be here.
Right.
Right.
The translator can't listen to it.
Right. That's why we're not going to play it in its entirety. It's practically impossible. So our intent was, we're going to call these translators, and they're going to, we're going to have them testify as to their transcripts, and that will be the evidence. And we could have a second party come in and play both of the participants. So one translator is going to play one participant, and then a police officer is going to come in and play the second participant. And I think it would be probably less than an hour, or probably about an hour or so for each of these to come in. To put it in a better context for the pagination, I think the transcript for the August 24th, I think, is around 16 pages. For the FBI translation for the multi-day, I think it's 44 or 45 pages. So that's what we're talking. We're not talking hours and hours and hours of playing video that nobody can understand. We're talking about people testifying regarding the transcripts.
All right, so why don't we do this, we'll just see where the road takes us. I don't think I can address anything at this juncture until we get there.
Will the court be open to the standing objection that these transcripts will become a focus of the trial improperly as this evidence comes in?
I'm not going to answer that now because I'm not committing to the transcript coming into evidence, period. I'm just allowing the witnesses to testify as to the substance of, they heard what's on 169 and 170, and this is what's being said. It's possible it might come in, and you may not even have an objection, because in my world, it's going to completely overlap anyway. You follow me?
Yes.
Yeah.
You may, that may just suit both sides, to do that, but especially if the amount that you said, that could be done.
Yeah.
Speak the transcript, essentially, where they're describing, I listened to this is what's being said.
Yes.
For all we know, the jurors are going to be writing it down on their notepads as well. I bet you they will,
Yeah. That was the
Right.
plan.
So the reason I answered you that way is you're presuming that I was going to admit the transcript. I may not. Right? Okay. All right, so we've hashed that out. And the irony is we're not even headed into that testimony right now. We're going back into the
We're doing DNA.
DNA.
Yeah.
Right? We're still on the DNA. All right, so do you want to bring in Mr. Walker and resume his testimony? Yes, let's bring in the jury, we'll continue. All right, jury is present. We continue with the testimony of Mr. Walker.
Good afternoon again, Mr. Walker.
Good afternoon.
All right, just two more items I wanted to ask you about. I want to show you what's been marked for identification. State's Exhibit 167. Earlier in your testimony, we talked about that you take extracts for every single piece of item you examine. Is that right?
Everything that I do DNA testing on has an extract.
Okay, and those are saved for multiple different reasons, one of those being that they could be sent to someone else if they wanted to also test that same item of DNA.
Yes, that's correct.
So I want to show you these two items that are inside of 167. Do you recognize those?
Yes, I do.
How do you recognize those?
So both of the items have the Indian River Crime Lab barcode sticker with the case number and exhibit number, and then I hand wrote what is in this item. So I made this piece of evidence. The extracts went into this manila envelope, and then I've labeled it with the crime lab case number, the sheriff's office case number, the exhibit number, and then what extracts are in both of these different items.
All right, what are the two different extracts? We'll start with the one that has the PR number 322696. What is that extract?
This is an extract of the blood standard from Tania Wise, and also inside is an extract of a reagent blank, and then there's a reagent blank number.
What's a reagent blank?
For every, when I work cases, we actually work them in batches, and I can work up to 13 samples at a time in an extraction set. One of those at least one of those samples has to be what's called a reagent blank, and the purpose of this is, how do I know that the DNA profile I get from a sample is actually from the evidence cutting I put in the tube and not from the chemicals or maybe my pipette tips or things like that? So a reagent blank goes through the exact same process, gets all the same chemicals added to it, but there should be no DNA in it. I don't add any DNA to this. And that will at least be at least one with each extraction set I do.
All right, and then the other item with PR number, this one doesn't, this, we'll go with, they just have this one marked as 296723-1.
So this is the extract of the swabs from the front passenger headrest and an extract of a reagent blank that was from this extraction set with this item.
At this time, the state would move what's been marked for identification into evidence as 167, into evidence as 167.
No objection.
Those will come into evidence at this time without objection.
Thank you, Mr. Walker. I don't have any other questions.
Cross-examination?
No cross-examination, Agent.
And do you wish to keep Mr. Walker under subpoena or release him, Mr. Caroni?
You can be released.
Any objection to releasing Mr. Walker?
No objection.
Mr. Walker, you are released from your subpoena. You're free to leave or stay as you wish.
Thank you.
Thank you.
William Houseman.
Stay with all William Houseman.
Houseman, if you'll step right up here. Raise your right hand to be sworn, please.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. Please step right this way. Just watch your step.
Good afternoon.
Good afternoon.
If you could state your full name and spell your last name for the record.
My name is William Houseman, Hausman.
All right, and how are you currently employed?
I'm currently the president of Prawn Seafoods Incorporated in Miami-Dade County.
All right, now prior to working for that job, did you have a much different job back in October of 2018?
Yes, back then I worked at DNA Labs International for approximately 5 years.
Okay, and if you could tell the jury, what is DNA Labs International? What do they do?
So DNA Labs International does forensic DNA processing.
Okay, and is it a private company? What type of company is it?
It's privately owned.
And does DNA Labs International do testing of DNA at times for law enforcement agencies?
Yes, that's primarily what they do testing for.
All right, what was your job title when you were employed at DNA Labs International?
I was a forensic DNA analyst.
All right. And to become a forensic DNA analyst, what is your background as far as education and training to be able to do that job back when you used to do it?
All right, so I have a bachelor's degree of science from biology at FAU, as well as a master's of science in biology at FAU, as well as going through a training program at DNA Labs International in order to perform DNA analysis procedures.
Okay, and back in 2018, you said you had worked there for 5 years?
Correct.
When you first began your employment with them, were you immediately allowed to work by yourself, or did you have to go through some on-the-job training or any other certifications?
Yeah, so there's a whole training regimen at DNA Labs where you learn new procedures and then you perform competency exams to show that you could perform them accurately.
Okay, and is that something that you went through?
Yes, I did.
Okay, and did you pass the examinations to be able to do DNA analysis?
Yes, I passed all those exams, as well as proficiency exams that were given twice a year by an external company to show that I could perform DNA analysis.
All right. Now, did you receive any items of evidence in reference to this particular case?
I did.
Okay, and do you know what those items were? Do you recall?
Yes. I have 2 items that I see here. One of the items was the extracts of swabbing from the passenger side headrest, as well as the extracts from Tania Wise.
And what I'd like to show you is what's already been marked into or entered into evidence as states Exhibit 167. There's 2 different ones. One is labeled as extracts of swabs from front passenger headrest, and the other being extracts of blood standard from Tania Wise. Is there any markings or identification on there that looks familiar to you?
Yes, I could see DNA Labs International uses their own tape, as well as the initials of one of my coworkers at the time.
Okay. And did you end up doing a DNA analysis in reference to these particular two items?
Yes, I did.
What type of analysis were you doing or asked to do in this case?
So what we did is we used a software called StarMix. And what it does is it helps us to evaluate DNA profiles that are mixtures, meaning that there's more than one person contributing to that profile.
And do you look at the standards? I guess, what is the process of how you do it? Do you run the unknown standard and then compare it to a known standard, or how do you do that?
All right, so as far as StarMix, what it does is it weighs two propositions against each other, developing a likelihood ratio. So you'll have weighing one proposition against another. So, for example, if you have 3 contributors in a DNA profile, it'll weigh the likelihood that one specific contributor, as well as 2 unknowns, is more or less likely than having 3 unknown contributors.
So for then the DNA extract from the extracts and swabs from the front passenger headrest,
Were through StarMix, were you able to determine whether or not there was a mixture of a DNA profile for that exhibit?
Yes, I was.
Okay, and what did it determine, or what did you determine in your analysis?
So the DNA profile obtained from the extract indicates a mixture of at least 3 individuals with at least 1 male contributor, and Tania Wise could not be ruled out as a possible contributor to this mixed DNA profile.
So the standard that you get from the extract of Tania Wise is compared to the mixture?
Correct.
Okay. And then you had referenced the use of propositions. Were there propositions considered in reference to Tania Wise's including, or I guess being in that mixture of 3 individuals?
Yes, so 2 propositions were considered, or I should say 2 sets of propositions were considered. So the first one is the DNA profile obtained from the extract is approximately 1.1 times more probable if the sample originated from 3 unknown persons than if it originated from Tania Wise and 2 unknown persons. Therefore, the strength of the support for either proposition cannot be determined, as the likelihood ratio is uninformative. Now, the second set of proposition that I did, the DNA profile obtained from the extract is approximately 4.5 million times more probable if the sample originated from Tania Wise and 3 unknown persons than if it originated from 4 unknown persons. Therefore, there is extremely strong support that Tania Wise and 3 unknown persons contributed to this mixed DNA profile, rather than 4 unknown persons.
All right. And when we talk about levels of support in your DNA analysis for mixtures, what is the lowest level of support?
I don't recall.
You don't recall what the lowest?
The
What's
lowest one.
what's the highest level of support?
So I'll tell you the highest level of support is extremely strong, which is what we see in this case.
I don't have any other questions for this witness.
Thank you, Judge. So, DNA Labs International, right? That's where
Correct.
you worked?
Correct.
Okay. And I think I heard your testimony to be that extremely, well, I'm sorry, what was the level there that you said?
Extremely strong support.
Extremely strong support that the extract that you received and tested was Tania and 3 other unknown individuals?
Correct.
Okay, got it. And at DLI, you all are capable of testing DNA samples that are pretty old, right?
Correct.
Okay. In fact, I think you all tested a sample that was 22 years old from some gentleman's molar. Do you remember that case?
I don't recall.
Okay, you didn't work on that while you were there?
I've worked on thousands of cases.
Including cold cases, right?
Correct.
Where the DNA is very old.
Correct.
Okay. So you can get DNA from a very old sample?
Yes.
Okay, no further questions.
Any further questions from the state?
There you are.
May Mr. Hausman be released from his subpoena?
Yes, sir.
Any objection to releasing Mr. Hausman?
No objection, Judge.
Thank you, Mr. Hausman. You're released from your subpoena. You're free to stay or leave as you wish. Thank you. And the state's next witness or item of evidence.
Yes, sir. The people of the state of Florida recall Donna Carmichael.
You've previously sworn this session today, so you don't need to be resworn. You're under the same oath previously administered to you. And Mr. Cormier, you may inquire of the witness.
Good afternoon. How are
Good
you? Yeah, how are you doing?
I'm good.
Good. So, were you a crime scene investigator that was involved in the search of the defendant's silver Dodge Ram pickup truck?
Yes, sir.
Okay, and how many times was that searched?
1 time on consent and 2 times with search warrants.
Okay, what are the dates? I'd like for you to spell out the dates of each search.
May I have permission to look at my notes so I make sure I have the right dates?
Yes.
Okay, on Saturday, August 25th of 2018 was the very first time that I spoke about earlier that we looked at the truck when the truck was in the Detective Bureau parking lot, that we searched or processed it then and took photos.
And that was a consensual search?
Yes, sir.
Okay. Next search, first search warrant, what was the date of that?
The vehicle was towed to the sheriff's office on August 27th. And then on August 31st, which is a Friday, we conducted the first official search warrant with an actual search warrant.
Okay. And
And-
then the second search warrant?
Okay, the vehicle was returned on September 10th to the owner, and then the sheriff's office again issued a search warrant for it and received the vehicle on Friday, the 21st, and we did the search warrant on Monday, September 24th.
Okay, so if I understand this correctly, the vehicle was in the sheriff's office custody from August 27th through November 10th continuously.
No, through September 10th.
I'm sorry, September 10th continuously.
Yes, sir.
And then it was returned to the defendant on September 10th.
Yes, sir.
And then the vehicle was taken back into sheriff's office custody on September 21st
Yes, sir.
of 2018, correct? And then it was searched on September 24th, is that correct?
Yes, sir.
Okay. And it was searched on August 25th, correct?
Yes, sir.
August 31st,
Yes, sir.
September 24th.
Yes, sir.
Okay, thank you. Okay, now, let me turn your attention to some Waste Pro videos. Did the sheriff's office receive into custody an SD card from a Waste Pro garbage truck on August 27th of 2018?
Yes, sir.
Okay, and did you participate in the collection of data from that Waste Pro garbage truck SD card?
Yes, sir.
Okay, I'm going to show you what has been marked as, I'm sorry, State's Exhibit 169 and also State's Exhibit 170. Have you reviewed the contents of States 169 and 170, both of which are external hard drives?
Yes, sir.
Okay. Is the data from the Waste Pro SD card that was collected on August 27th of 2018, was it placed and provided to David Mingarelli of the FBI in order for him to enhance the audio and video of it?
Yes, sir.
Okay. And is that data used in both of these exhibits?
Yes, sir.
Okay, thank you. And Your Honor, the state moves into evidence 169 and 170.
Any objection?
No further objections, Judge, other than what we previously discussed.
Those items will come into evidence at this time without objection.
And Ms. Carmichael, thank you. That's all the questions that I have.
No, Your Honor, no questions.
May she be released at this time?
She may.
Any objection to releasing Ms. Carmichael from the defense?
Yes.
From the defense, no objection.
No objection, Judge.
Thank you, Ms. Carmichael. You are released from your subpoena. You're free to stay or leave as you wish. And the state's next witness or item of evidence.
Yes, sir. The people of the state of Florida called David Mingarelli.
You swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And you may inquire of the witness.
Afternoon.
Afternoon.
Can you state your name for the record and spell your last name, please?
Yes, my name is David J. Mingarelli, spelled Mingarelli.
Okay, and what do you do for a living?
So I am employed with the Federal Bureau of Investigation. I'm a senior digital forensic examiner. I've been employed as such for the last 16 years in the Miami field office.
Okay, and what does a senior digital forensics examiner do for the FBI?
So the major part of my responsibility is collecting, inventorying, processing digital evidence. That might be cell phones, loose media, thumb drives, laptop computers, video surveillance systems, things of that nature. I'm also trained in forensic audio and video processing and enhancement. The last 3 years I've been in charge of the digital video retrieval training program, which is based out of Huntsville, Alabama.
Okay, and go ahead and describe your education and your training and your experience to the jury, please.
So, as part of being a forensic examiner with the FBI, we have internal training and certifications that we are required to take and maintain our levels. There's yearly trainings, yearly proficiency testing programs, outside education, outside vendors provide training for continually evolving technologies.
Okay, and do you have any experience with enhancing audio and video as it relates to evidence that comes into possession from law enforcement?
Yes, I've been trained to process and enhance audio and video as it relates to digital video images and still images.
Okay, and does that, when you say enhance, does that make it easier for a user to understand?
Yes, the primary goal is to enhance the intelligibility or either the viewability or audibility of video recording or audio recording.
Okay, and I want to show you what has been entered into evidence as State's Exhibit number 169, which is a video, or I'm sorry, external hard drive that contains video from August 24th of 2018 from a Waste Pro garbage truck. Are you familiar with that item of evidence?
Yes, I am.
Okay, go ahead and explain to the jury what that is.
So that is the video that I processed initially related to this case. Initially, I was asked to review video footage from a Waste Pro garbage truck for the date of 8/24 of 2018. The video was provided to me. The video, as it came in, was in individual 1-minute pieces for the hourly folders. So each folder was separated by hour for the day. We had 1-minute chunks of video. That video was combined into hourly chunks and then to a daily chunk for 4 cameras. Of primary interest when the request came in was the in-cab audio, which was identified as camera 1. So there was a audio track that went along with the video. So that audio track was extracted from camera 1. It was noted that there was some mechanical noise and what we would identify as broadband noise, which is just environmental type background information or that distracts the user from the ability to listen to a conversation or voices in the cab. So when I examined the video, I noticed primarily the fan. There was a fan running, making a clicking noise. So I was able to isolate a sample of that fan audio noise and use that to basically quiet that fan noise down. So it's basically you take a sample, then you use that sample to eliminate the fan noise or lower the level of the fan noise. So the voice conversation would be a little clearer.
Okay. And can you explain to the jury what a hash value is?
So a hash value is in this case, I provided MD5 hashes on my files. The MD5 hash is a mathematical algorithm. Basically, you pass a data stream. I use a tool that's capable of understanding and generating MD5 hashes. So in my case, I pass my file through an MD5 hash algorithm. It generates a unique fingerprint, if you will. It's a mathematical character representation of the data stream. It's to guarantee that my video files have not been changed in any way since I originally created them. So if I was to take those video files and hash them again, I could verify that those files are intact and have not been altered in any way.
And are there hash values contained in exhibit number 169 from the August 24, 2018 video?
Yes, there are.
Okay. And you said that you were able to enhance the quality of the sound, and you mentioned the fan. Can you walk the jury through the specifics of what you did, what type of software you used, and how you actually carried that out?
Yes. So once I combined the videos from the individual cameras and generated the daily camera, I was able to extract the audio track from camera 1, which is what was of interest in this case. That audio track was then brought into, we use the program called Isotope. It's primarily used for audio and post-production audio. So recording artists, things like that, we use that type of software in order to clean up vocals, remove ambient noises, mechanical hums, things like that. It has other features that remove clicking and hissing. It has a feature called denoise. That denoise feature is what I utilized in this case. I was able to isolate an area of the sound where the fan was clicking. I sampled that audio, and then I used that to lower the level of that fan throughout the rest of the video as that fan was playing, which allows anyone that would listen to that file to focus more on the voices if anyone was speaking in the video. And then that audio track, that enhanced audio track, was added back to a quad camera layout that I created. So using Adobe Premiere, which is Adobe Premiere is a video editing software. I loaded the 4 cameras into a layout so you could see them simultaneously. Since they were in 1-minute chunks, they were very difficult to watch, and that was why the original request had come in. It was very difficult to watch 1-minute chunks of video. So the files were all merged together, and then the audio was cleaned up, added back to that quad view, and then rendered and produced. And that's what I provided on the hard drive.
Okay, and did the methods that you just described ensure the accuracy and the genuineness of the words that were spoken between those two individuals in the Waste Pro video? In
Yes,
that
they
video
did.
right there?
Yes.
Okay, and just by you using it, did it actually improve the audio of it and the understandability?
Yes, it did improve the audibility to me.
Okay. Now I'm going to show you what has been introduced into evidence as State's Exhibit 170, which are videos from the dates of August 21st, August 23rd, August 25th, and August 27th of 2018. Do you recognize that exhibit?
Yes, I do.
Okay. Explain to the jury what that is. Thank you.
After I had processed the first video on the 24th, the state's attorney's office requested that I perform the same procedure on these additional dates. And so the difference here is that at this point, the videos, rather than me stitching the original videos as I did on the 24th, so taking those 1-minute pieces and combining them into hourly and then the hourly into a daily for each of the cameras, those videos were provided to me already stitched together. From that point on, I performed the same process. I located the audio track from camera 1, loaded it into Isotope, used the audio filtering that I used before for the fan to lower the noise of the fan, and then took that audio track and merged it back to camera 1, and then rendered a file that contained the 4 camera views with the enhanced audio overlaid.
Okay. And same question, did that process ensure both the accuracy and the genuineness of the words that were spoken between the two individuals in the Waste Pro trial?
Yes, it did.
Okay. And did it actually improve the audibility and understandability of it?
Yes, it did.
Okay. State's Exhibit 170, was that particular, or at least a digital copy of it, provided to a translator from the FBI named Norma Campos?
Yes, it was.
Okay, and turning your attention back to State's Exhibit 169, which is the Waste Pro video from August 24th of 2018, was that also provided to a private translator by the name of Rose Rosario?
Yes, it was.
Okay, thank you. Mr. Mingarelli, thank you so much. I have no further questions for you.
Thank you, Judge. Sir, just so I make sure that I understand, on the days in question, there would be separate folders per hour, and each folder would have 60 sub-files in it, 1 per minute, right?
If it was an entire hour, then there would be 60. I believe on some of them, the video might have started at 30 minutes or 40 minutes, so you would only have the remainder of the hour. But it was 1-minute chunk of video for each camera separated into hourly folders.
Okay, but some of the files were missing some of the videos. Do you recall that?
The files that were provided by St. Lucie County Sheriff's Office initially, when they had merged the files, once I received them, I realized that I was missing some video. So my understanding was it was just during the merge process. They did not merge properly. So I had made the request back to the St. Lucie County Sheriff's Office, and they had sent corrected files.
Okay, so all of the files didn't get to you the first time, but the second time they did get to you.
That's correct.
Okay, but we didn't convey it properly the first time. Is that accurate?
That's correct.
Okay, no further questions for this witness.
No further questions, thank you.
May Mr. Mingarelli be excused from his subpoena at this time?
He may.
Any objection to excusing him from subpoena? From the defense?
Judge, we'd ask that he remain under subpoena momentarily.
Okay, you do remain under subpoena. You may step down. Please be sure if the attorneys, you want a contact number for him to get a hold of him if you want to recall him?
Yes, please.
Okay, thank you. You may step down. And the state's next witness or item of evidence.
Yes, sir. The people of the state of Florida call Adolfo Cavelli.
What was the last name again?
Cavelli,
Cavelli.
C-A-V-E-L-L-I.
sir.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Over that way to what's the
Yes, sir. Thank you, sir. Yes, sir. Good afternoon.
Can you state your name for the record and spell your last name, please?
Yes, sir. Adolfo Cavelli Jr., C-O-V as in Victor, E-L-L-I.
Okay. And were you working at Waste Pro back in August of 2018?
Yes.
Okay. What did you do for them?
I was the assistant division manager at the end of the career there, but I was basically an operations manager. And I was over the trucks, which was 2 supervisors below me and then the drivers below them, and watch after the operation, the maintenance, and the safety.
Okay. And when you say operations manager, go ahead and just briefly describe what that entails.
Okay, so just in the day-to-day operation, so get there in the morning, drivers check in the morning, make sure we have the vehicles for them and their routes, get them on their routes to go pick up the trash, was over their safety, made sure I met with the route managers to make sure we take care of any issues with driver call-outs, vehicle breakdowns, and items like that, and then make sure we get the garbage picked up every day.
Okay. So if we were to envision a chain of command for Waste Pro in August of 2018, where would you have fallen?
Okay, towards the top. So right above me was the division manager. That was the highest person at the local office, Darlene, and then I was below her as the assistant division manager, which was really just a title change for a pay adjustment while I was transitioning into her position when she retired. I did not make it that far. I left before then, but that was it. So it was the division manager and then myself, I guess you would say number 2 in command, but number 1 over the operations.
Okay. And while you were there at Waste Pro, was there an individual named Jose Soto-Escalera that worked there?
Yes.
Okay. And did he fall below you in the chain of command?
Yes.
Okay. What was his position?
He was a residential driver.
Okay.
Picked up garbage at the houses.
Okay. Did he report to you, or was there an intermediary layer in between?
Correct. We had 2 people. So there was route managers or route supervisors. So the chain of command for Jose was myself, then Mike Smith or Michael Smith, and then Jose.
Okay. And did Jose's wife work there as well?
Yes. At the time, Deb Kendall was the other supervisor.
Okay. And where did she fall in the chain of command?
So her and Michael were equivalents. So it was Darlene, then myself, and then Deb and Mike, and then the staff of drivers.
Okay. And did you, you said, I believe, that Jose Soto-Escalera was a driver, is that right?
Yes.
Okay. What is a prerequisite to becoming a garbage truck driver at Waste Pro?
In order to drive a vehicle for ours, you need a commercial driver's license, a CDL Class B, as in boy, with air brakes.
Okay. Gotcha. And if you did not have a commercial driver's license at Waste Pro, were you allowed to drive one of the garbage trucks?
No.
Okay, so you had to have the CDL, is that right?
Correct.
And did Jose Soto-Escalera have a commercial driver's license?
Yes.
Okay. Are you familiar with an individual by the name of Eric Alvarado?
Yes.
Okay, who is Eric Alvarado?
He was a helper for Waste Pro. At the time, he was Jose Soto's helper. I believe they were also related. I'm certain that it was his nephew.
Okay.
Jose was the uncle of Eric Alvarado.
Okay. Did Eric Alvarado have a commercial driver's license?
No.
Okay. So was there ever a circumstance where Eric Alvarado would have been allowed to drive the Waste Pro garbage truck?
No.
Okay. If Eric Alvarado attempted to drive or drove a Waste Pro garbage truck, what would have been the consequence?
Well, if I found out about something that somebody was driving that should not have been driving, they would have been terminated.
Okay. Okay. So swift and immediate consequence.
Yes.
Okay. So let me turn your attention now to the Waste Pro garbage truck. There is a Waste Pro garbage truck, I think, named number 1363. Are you familiar with that truck?
Yes. 1363. Yes.
Okay. Who was assigned to that truck in August of 2018?
Jose Soto.
Jose Soto-Escalera?
Yes.
Okay. Was he the driver of that truck?
Yes.
Okay. Was that truck outfitted with a camera system?
Yes,
Okay, and did that camera have an audio system as well?
yes.
Okay, can you go ahead and explain to the jury the camera system from Waste Pro garbage truck number 1363?
Yes. The garbage trucks, for those type of garbage trucks, it was called a residential rear load garbage truck. We had 4 cameras and 4 audios. So we had a camera facing out of the front of the truck. So if whoever was driving, it was what the driver was seeing. So there's a camera facing forward. There was also a camera in the cab of the truck, finding out what was going on in the cab along with the audio. There was also a camera and audio in the back of the truck. The back of the garbage truck you call a hopper, and that's where the garbage goes in. So in case someone got hurt back there, whatever, there was a camera back there also for accidents. And then there was a 4th camera on the driver's side looking backwards. So basically what the driver was seeing, if he was looking in the rear view mirror on the driver's side, it's what the camera was saying, is what he was saying from the camera.
Okay, so can you explain to the jury why Waste Pro had this camera system? Why would a garbage truck have all of these cameras?
So we put them in, it's now pretty much standard in garbage trucks and buses, put in for safety measures. Originally put in for, if someone rear-ended us, but, they were gonna sue us for getting for us slamming on the brakes, we had the video to prove otherwise. We are also used for measures for improved safety metrics. If a driver was eating while driving, that's a no-no. Talking on the phone while driving, that's a no-no. So it was, again, put in to improve our culture.
Okay, and was there also a microphone located in the Waste Pro garbage truck number 1363?
Yes.
Okay, explain to the jury where the position of the microphone is.
Okay. So the audio in the video in the cab of the truck was more, if you look at the cab, like it's 100% wide, it was more on the first third, more for the driver, right? So probably like 35% in from the driver's side, so 2/3 from the passenger side, so more on the driver's side.
Have you had occasion to listen to videos and audios from those Waste Pro garbage truck based on your job experience?
Yes.
Okay. Is it easier to hear the person who's seated in the driver's seat versus the passenger seat? Is it equal? Tell the jury about that.
Okay. So it's definitely easier.
Objection, Judge, may we approach?
Sure.
With instructions.
Okay. So, and you're familiar not just with this one particular Waste Pro truck, but all of them?
Yes.
Or
at the
most
time-
of them at the time?
When I was working, yes, for the vehicles that were at my location.
Sure. And are they laid out in essentially the same way with cameras as you've previously described and a microphone in the same location as you previously described?
Yes, for all the residential rear loaders, that type of truck, they were all the same.
Okay, okay. And as part of your job, did you have occasion to listen to and watch camera footage and also listen to audio footage from other trucks during the course of your employment?
Quite often.
Okay. And how often would you do that?
I would say it would be regularly, depending on the week, but it could be as easy as someone saying that their garbage was missed, to an accident, to an altercation on a vehicle. I would say easily 1 time a day, maybe more.
Oh, wow,
But
okay.
yeah, I would say 5 days a week, 5 times a week, maybe not all once a day, but maybe 3 on one day, 2 on, but 5 a week maybe.
Okay. And based on the placement of those microphones and all of those trucks, is it easier to hear the driver versus the passenger? Is it equal? Tell the jury about that.
Yeah, so again, just speaking about the residential rear loader and those type of vehicles, those cameras, again, were closer to the driver, so the audio, I don't know if the microphone faces a certain way, but it was a lot easier to hear the drivers over the people in the passenger seat.
Okay, thank you. Finally, let me turn your attention back to Jose Soto-Escalera. Describe your relationship with him. Was he an acquaintance? Was he a friend? Was he a good friend? Was this an employment relationship? Tell the jury generally about that.
It was an employee who became an acquaintance. Most of my staff acquaintances, employees. Yes.
Okay. Okay. Did you ever have any kind of a beef with him or anything?
No, not. Oh, I'm sorry.
Can we approach it?
All right, with the court's instructions, you can rephrase the question.
And you've never had a problem with the defendant, Jose Soto-Escalera?
No, sir.
Okay. And do you see Mr. Soto-Escalera in the courtroom today?
Yes.
Can you point him out and describe an article of clothing that he's wearing?
Blue shirt, black jacket, and glasses.
Okay. Thank you very much. I have no further questions.
Yes, sir.
Cross-examination?
No cross, Judge.
May Mr. Crivelli be released on the subpoena at this time?
He may.
And then
Actually, no.
You want him to remain?
Yes, sir.
Okay. You do remain under subpoena. You may step down, subject to recall by the attorneys.
Yes, sir. Thank you, sir.
You're welcome.
Commissioner Ferguson.
Sure. That's actually going to conclude our work with you today. We have some other work to do after you leave. As I told you, we will take as much work as we can outside of your presence before you get here, after you leave, so as to take up as little of your time as is necessary. Please remember, don't do any research about the case. Avoid all media reports of the case. Don't talk to anyone, including your fellow jurors. Please leave your notepads on your chairs. Tomorrow morning, 8:45, same procedure as you followed today. Enjoy your evening, and we'll see you in the morning. We'll be working on the case in the meantime. These items, they'd be able to testify as to portions of it. Whatever portions they testify to on direct or on cross will be able to be played for them. Whether you want to do that or not, it's up to you, but they can be played for the jury. It's evidence. Also, same thing, while they're deliberating, they have to come into the jury room to listen to that. With regard to a transcript,
It's coming to the courtroom.
into the courtroom, right, to avoid that. That's the main purpose of that. The issue about where I think I was wrong and misspoke, and I was actually doing what I was accusing you all of doing, which is confusing that Marshall situation with this. The part about the jurors maybe be able to speak Spanish and doing that, that is what it is. If they have Spanish abilities, they hear it, they're allowed to draw any conclusions, just evidence like any other evidence. So when you're picking the jury, that kind of was built into this case. I'm not sure if it hurts or helps either side. That's not my concern. But so they'd be allowed to do that. The transcript part of it really is just the situation of if you agree. If you do not agree, I would not allow a transcript to come into evidence, because that's equivalent of any expert saying, here's my testimony in the case. Not only did you hear me, but now you have my testimony going back with you. If you wanted to use it as a demonstrative aid, I might be open-minded to it, just to be sure that it actually says exactly what they're testifying to while they testify, like on your screen or something like that. But I think that's pretty clear to me that that's all proper and would resolve any issue in that regard. So some of that came a little bit clear, particularly after Mr. Burns' objection to the transcript, if it were to go that route. And it's legitimate. Just imagine if you call the witness and they only testified to portions of it, and you put the whole transcript in, that's even worse than the scenario. It's not only is it, here's my testimony, it's here's my testimony that I didn't even testify to. So with that, and hopefully, while you were talking to me before, and Mr. Richardson said it was like a year long or something, whatever that was like everything that's on those, not the portions that we're relying on were I think you said one is like 44 pages. So,
Yes.
So that's something that you'd have someone, there's no way around that. That's what they have to do. But probably more importantly, the issue about the jurors potentially understanding Spanish, that, like I said, that's built into the case. I think if I were, listening to, I was dissecting what I said, I'm like, what's the problem with that? There is no problem with that. If they speak Spanish, they're able to do that. Versus the scenario, what I was conflating it in with is you have someone who speaks Spanish and we're having a court interpreter, that's where the jury is supposed to rely on the interpreter and not use their Spanish. This is different. This is actual evidence in the case, so.
Well, you'll recall we asked the questionnaire about their ability to speak Spanish. So we did know.
Right. And this is South Florida, which is an interesting dynamic too. And the Exhibit A for that would be that your witness is at the moment also in a trial in Broward County with the identical situation. I bet you if you went to all 50 states, maybe only California would have this situation where at the same time, within a geographical area, you have an expert witness doing the same thing. But I welcome you if you want to make those phone calls and see if we can get that resolved. That would probably help keep the flow. Especially now that I'm told by Mr. Burns that the state is not calling Mr. Alvarado, because that takes a big chunk of time left for our, it could be that we have dead time and we're waiting for something. So does that change as far as, let's segue into a whole, where are we going time-wise?
Well, I was just going to say earlier, you might expect this evening or tomorrow morning, when I can get my ducks in a row, to receive a motion to incur costs to get my witnesses here from Connecticut and from Puerto Rico. It's going to be $8,000 to $10,000, I think, transportation and whatnot. And because I think the state's fixing to maybe conclude a little bit earlier, we're running a little bit early.
Sure.
I'm trying to get them here as quickly as we can.
If you do that, as I did with Ms. Mitten's motion on the depots, I always have my laptop with me wherever I go, because it's part of the nerd rules of procedure. You must travel everywhere with your laptop.
Quite remarkable, Judge. Day, night, weekends, we hear from you, yes.
Right, so I'll be able to e-file that whenever I get it, which would facilitate what you need to do.
Yes.
I completely understand the bind that you're in there. I'll get that done as soon as possible. There was an issue about JAC getting emailed on it and the other thing, but that's really not my concern.
We're going to have to move faster than Jack, I think, here. Judge.
Yeah, and
Yes.
they've expressed through their email that we're not requesting a hearing on it, so I'll get that done as soon as I see it come through.
Thank you,
So-
Judge.
To follow the same procedure Ms. Mitten did, where it went directly to me as well on the email.
Yeah, it's going to probably come through her office.
Okay.
I was about to say, Judge, she's pretending like he's going to do it. I'm
Yeah, I
sure
can't really be
do.
trusted with that type of stuff, Judge.
All right, anything else from the state for us to address, or?
Yeah, I mean, the only thing, of course, I am going to call the ASA who is responsible with Ms. Rosario in the event that we can't get that worked out. And frankly, I don't think it's, I'm sorry to say, I don't think it's going to work out. I've already spoken to her. That was a few weeks ago, though.
Right.
I was been texting Ms. Rosario here today. So I'm going to try, obviously,
Right.
but I don't know if we can pull it off. So that would
I
mean,
understand.
yeah, that would mean that we would have to take her Thursday. So I would only have just a handful of witnesses
Right.
tomorrow and then Thursday.
So we're
I
on the record.
appreciate you're doing everything you can do. I know of a case, there's a judge, I think ironically, perhaps in Broward County, who would say, call your next witness, and if you don't call the witness, then they'd dismiss the case, which is just, I've never done that. I would never do that. It's completely inappropriate. And I appreciate your effort to do that. Some of this is built in. I'm just going with, in the best case scenario, you're able to work it out and we're able to move things along.
Yeah.
If that's how it is, I would even be able to explain to the jury, which you may want to consider, we would be proceeding, except the next witness unfortunately has to testify in another trial in another part of the state. So that's the reason for the delay, if you're concerned about that. Otherwise, I would just not touch that.
You remember Judge Trowbridge?
Oh, I tried many cases before Judge
I
Trowbridge.
would hate to have to tell Judge Trowbridge, I don't have a witness right now, Judge.
Well, that segues very well for when we're off the record. I'll tell you my court TV experience that I had with Judge Trowbridge back when the dinosaurs were roaming the earth. And I think you all will appreciate that story now that we've the roads have met in that regard. All right, so nothing else to take, and we'll be adjourned until 8:45 in the morning tomorrow. We'll continue. The good news, too, I think the state would say we're ahead of schedule, basically.
We are very far ahead of
I
schedule.
mean, really, the goal with this case was to resolve the guilt phase this week, one way or the other.
Oh, we're definitely there, I think.
Okay, great. And I had sent you all my before we started the evidence, my proposed changes to the jury instructions. I don't know if you got that.
We received it.
Right, so I have that because we talked about charge conference, there's only like a few issues to discuss. One of the issues on there too is, and you're probably gonna want it, but I don't know. Part of the murder instructions deals with the heat of passion part of it. So I don't know if you want that or not. You're probably gonna say yes. I just assume so. But other than that, the other interesting thing was, as I remember, the charge that says count 1 and count 2 are separate, you should consider them separately, which I think we should take out because they're bound together in this case. So
Right.
something else to think about.
I don't disagree with you, Judge, like logically, but legally, I'm gonna ask to keep that instruction in.
So something for the state to
We're gonna,
contemplate.
yeah, we'll sleep on that one.
Yeah.
Yeah, sleep on that one, because my concern there would be confusion of the jury. I don't want to take away the jury's pardon power, but the law has always been that I'm not supposed to instruct them on that. You know, it's not, you can't argue it to the jury, but they have it there. And it really wouldn't be eliminating it to avoid that instruction. The problem is I'm inclined to think it's a contradictory thing, and it would just cause confusion. Unless you can think of a scenario that I
can't.
haven't, which I'm open-minded to. Sometimes there's a scenario that I haven't thought
I
of.
have a legal argument that I'm going to make that
There could be
necessitates
some,
that.
there could be some factual scenario living. Okay, maybe I'm thinking of the same thing here. We'll find out. But so something for the state to ponder too. Right.
Don't limit me.
All right, we'll see you tomorrow then. We'll be adjourned until tomorrow morning.
Thank you, Judge.
Go off the record.